Kansas law defines consent very basically, so it leaves a lot of gray area. What it says is it's simply consent means that the other party is agreeing to or willing to participate. It doesn't give any specifics like they are verbally out loud saying they consent or specific requirements as to what consent is. It just says that it is when the other party is agreeing to or favorably in the act. Both Kansas and Missouri, you cannot consent, meaning you legally cannot consent, even if you say, I want to do this, if you are under the age of consent. In Kansas, the age of consent is 16 years old. So if you are 15 years old and you say, I wanted to do this, unfortunately, legally, you cannot agree to that. You cannot consent to a sex act. In Missouri, the age of consent is 17. So the same thing applies. You cannot consent if you're under the age of 17. You simply cannot legally consent to any type of sex act. Now, there's also the added element, oftentimes when sex or sex acts are involved, of drugs and alcohol. And this is kind of a catch-22 because for an individual who is charged with any type of crime, voluntary intoxication is simply not a defense. So the individual charged cannot say, I was too drunk, I didn't realize what I was doing, or I was too high, I didn't know what I was doing. That cannot be a defense as long as it was voluntary. Now, if it was involuntary, meaning that someone put drugs into your system without your knowledge, or someone spiked your drink without your knowledge, then that's a different situation. And something that we would have to investigate and try and help get evidence for to prove that it was involuntary intoxication. However, when most oftentimes, statistically, it is voluntary intoxication, and that is not a defense for defendants. But whereas the catch-22 comes into play, an individual who, whether voluntarily or involuntarily, is intoxicated, either by drugs or alcohol, they cannot consent. Okay, so what that means is it's believed or proven that an alleged victim was intoxicated, highly intoxicated, high, on drugs, then they cannot legally consent to a sex act. So it's not a defense for individuals charged that they're voluntarily intoxicated. However, alleged victims who are even voluntarily intoxicated, they cannot legally consent. So you could have two individuals who are both voluntarily intoxicated, and the state can say that the alleged victim's voluntarily intoxication means that they were too drunk to be able to consent, and the defendant's voluntary intoxication, it does not matter, it does not apply, because they were voluntarily intoxicated. So when it comes to drugs and alcohol, as far as sex crimes is related, it is very, very important for you to be open and honest with your attorney so that we can make sure that we have navigated every possible situation that might come up with your case in regards to drug and alcohol use, both before, during, and after any type of incident like this.